This is case number 24-CR118, State of Ohio versus Matthew Seagraves. Present for the state is Prosecuting Attorney Collins. Present on behalf of the defendant's attorney, Catherine Hapner. And are you Matthew Seagraves?
Yes, sir.
Mr. Seagraves has been charged with 2 counts of assault, a peace officer, a 4th-degree felony. Mr. Seagraves has been presented a plea of guilty form, which indicates you're going to withdraw your not guilty plea and plead guilty to count 1 of assault on a peace officer under 2903.13a, 4th-degree felony. Now, this is a 3-page document. On page 3, there's a sentence at the end of the text that reads, "I enter this plea voluntarily." Below that appears to be a signature of M. Seagraves. Is that your signature?
Yes, sir.
All right, and when did you sign this document? Just this morning?
Yes, sir.
All right, and did you go over with your attorney before you signed it?
Yes, sir.
And did she explain things to you and answer any questions you had?
Yes, sir.
Now, when you came here today, did you understand that you were coming here to enter into a plea agreement?
Yes.
And you'd been talking with her before today?
Yes.
Speak up a little bit more, if you would.
Yes, sir.
Yeah, we talked about it in my office last month.
Okay. And so this is not a surprise that you're doing, that this document was here for you to sign? Okay. Now, did you sign this document voluntarily?
Yeah.
And are you going forward today voluntarily?
Yes, sir.
All right, keep your voice up.
Yes, sir.
Yeah. All right, now, the document says on page 1 that you understand that the penalty for this offense could be 6 to 18 months in prison, could be a fine of $5,000. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
No, sir.
Are you currently on community control, probation, parole, or post-release control for a felony?
No.
Now, under the law, if you should be sentenced to prison for this offense, then upon completion of that sentence, it is possible that the adult parole authority would place you under what's called post-release control for a period of up to 2 years. And what that means is that you would be supervised under the conditions they set, and if during that period of time they determined that you had violated those conditions, then they could return you to prison to make you serve an additional period of up to 9 months for any single violation, but there is a cap or limit of half of whatever your prison term was for all violations. If you are convicted, however, of a felony while under post-release control, then in addition to whatever sentence could be imposed by the judge in that case, the judge could also sentence you for committing that offense while under post-release control in this case, do an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in a new case. Do you understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control, which means that instead of going to prison, you would be put under the supervision of a probation officer for a period of up to 5 years under term set by the court. If during that period of time the probation department felt that you were not complying, they would file a written allegation of that with the court and give you a copy. There would be a hearing. You'd be entitled to have an attorney at that hearing. If the outcome of the hearing was that you had failed to comply, then at that time the court could sentence you to a period of 18 months and fine you $5,000. Do you understand that?
Yes, sir.
I've neglected to ask at the beginning of the hearing, Ms. Collins, has the alleged victim or victims of the offense has been notified of the time, place, and purpose of this hearing, the right to be heard?
They have, Your Honor, and both have stated they will not be attending hearings.
All right. Now, the charge in count 1 alleges that on or about July 29, 2024, in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to V1, a peace officer, as defined in ORC 2935.01 of the Ohio Revised Code. 2903, and that would be in violation of 2903.13a of the Ohio Revised Code, the assault on a peace officer with the penalty I've just described. Now, do you understand what it is Do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
You understand what you're being charged with
Yeah.
and when it occurred? I mean,
The date was alleged July 29, but you understand what incident they're talking about, what they're saying you did.
I know we talked about you didn't have a whole lot of memory of it, but you remember
No,
that?
I don't remember it, but I remember waking up in jail.
Well,
Remember the
I'm not
incident?
asking you to remember, I'm just understanding if you understand
Yes, sir.
what they're saying. Okay.
Yes,
Now,
sir.
all right, good. Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
We talked about this in my office. You remember
Yeah.
you came to my
Yes.
office and we talked about it? Okay. And did I answer all the questions that you had at that time?
Yes, ma'am.
And are you satisfied with her advice and confidence in this matter?
Yeah.
All right. Has anyone threatened you to make you plead guilty here today?
No, sir.
Has anyone promised you anything to get you to plead guilty other than what is set forth in the plea agreement here?
No, sir.
And are you under the influence of any types of drugs or alcohol at this time?
No, sir.
All right, now the agreement states on page 2, there's a couple of lines printed in bold and underlined that read that defendant shall enter plea of guilty to count 1, state will dismiss count 2, state and defense jointly recommend community control, 30 days jail, and residential substance abuse treatment. Is that your understanding of the agreement?
Yes, sir.
Okay. Now, under the law, Mr. Seagraves, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement as to what your sentence ought to be, if you enter that plea here today, I'm not required to follow that. I could decide to impose a prison term of between 6 and 18 months, and I could fine you $5,000. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
You don't have any special license like nursing or teaching or anything like that?
Not in Ohio, no.
Okay. Now, do you hold one in some other state?
I mean, no.
I mean, I'm talking like a vet tech or a pharmacy tech or an engineering assistant or something like that.
No, sir.
Okay. Now, you have certain constitutional rights you must understand before I can accept a plea from you. Well, this thing won't turn on. Got that? First of all, you have a right to counsel, and I appointed Ms. Hapner to represent you. Now, that wasn't simply to work the case out, but provide any defense that might be available to you under the law that you'd like her to provide. So, if you decide you do not want to plead guilty, she'll continue to defend you, including a jury trial, if that's what you want. You understand that?
Yes, sir.
Now, under the law, Mr. Seagraves, you do have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, they would be instructed on the law, and then that jury of 12 people would decide by unanimous verdict, meaning all of them would have to agree, all 12, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, the right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court will issue a subpoena, which is a court order, and that court order would require those people to come into court to testify on your behalf if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's up to you to make the decision whether to testify. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to talk about it with one exception. If there's a jury trial and you don't testify, the judge does instruct the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't upon the state to prove the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused by the state. In fact, under the law, you don't have to put on any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and that plea exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime. And that plea waives or gives up all the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. So with that exception, your plea of guilty waives or gives up your right to a jury or court trial. Waives or gives up your right to confront witnesses against you and to cross-examine through your attorney. Waives or gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. It waives or gives up your right, your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under other certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
There was a lot to digest.
Yeah.
You get all that?
Okay.
So,
Now, you have any questions about the charge or the possible penalty?
No, sir.
You understand that?
Yes.
You have any questions about the plea agreement?
No.
You understand it?
Yes, sir.
And you understand the recommendation on sentencing is not binding on the judge?
Yes, sir.
You have any questions about the constitutional rights I've just explained?
No, sir.
Do you understand those?
Yes, sir. Yes, sir.
Keep your voice up. All right, do you understand? All right. Do you have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
No, sir.
You understand that?
Yeah.
Now, is there anything more you'd like to speak with Ms. Hapner about before we go any further?
do you have any questions for me?
Okay. Then do you have any questions at all about anything I've explained to you here today?
No, sir.
All right, then is it your decision to withdraw your not guilty plea, plead guilty to count one pursuant to the terms of the plea agreement we've just gone over?
Yes, sir.
Yes, stand
All
up.
right, then, as to the charge, which alleges that on or about July 29, 2024 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to V1, a peace officer, as defined in ORC Section 2935.01 of the Revised Code, in violation of 2903.13a of the Ohio Revised Code, the offense of assault on a peace officer, fourth-degree felony, carrying a possible sentence between 6 and 18 months in prison and a fine of $5,000. How do you plead?
Say real loud.
Guilty.
All right, thank you. You can be seated. All right, the court finds on this day in open court, defendant is advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal rule 11. The pleas accepted, order filed. Defendant is found guilty of count 1, count 2 is dismissed. The court will refer the matter to the probation department for a pre-sentence report. Bond will be continued, and you will be sentenced on January the 8th at 9 a.m. The bailiff will give you an assignment notice here for that. And as soon as you get done here, you need to walk down to the probation department, tell them you've entered a guilty plea so that they can schedule you for your pre-sentence interview. All right.
Your Honor, the guilt on credit sheet says he's not reported for processing into jail.
Oh, okay.
Storage.
Oh, okay. Well, when you go down to the probation department, after you get done there, you need to go out to the jail because they don't have you I think you were booked in obviously before.
Yeah, he was booked
But
in.
they don't have you booked in on this charge.
Okay.
They have to do one for each separate charge to send to the state.
Doesn't make any sense. He was arrested on
Yeah,
this
he was
charge.
arrested, that's the thing, he was arrested on this charge.
He
so why
was.
would they?
After he's indicted, there's another, they do it again.
Okay.
But
That makes no sense to me, but
Yeah. And of
Just go
course-
out there and get it done.
And then they had asked him if he'd been out, and he said yes, because
Yeah,
he had been.
yeah.
So we report down to the probation department, and then at some point,
All
like
right.
today,
I
this
don't know what's
afternoon, you'll
going
need
on
to
with
go
this
out
freaking
to the
computer.
sheriff's department, there's gonna be your picture and your fingerprints again. They're not gonna hold you, they'll just take your.
Yeah, you're just gonna be printed and so forth, because they have to send it into the state, so.
And then you'll walk out of there, okay?
So go see
Are you Bradley B. Hickson appearing there from the jail? Hello? Oh, he's muted. There we go. Are you Bradley Hickson appearing there from the jail? Oh, still muted. Okay, according to my screen, your mic is on. Officer, can you hear me? Nope.
I think we had this issue a couple weeks ago.
Well, we had it on my end, and I had to go in and fix my mic. For some reason, I've got like two different microphones and speakers, and my speaker wasn't working, and sometimes it flips, and who knows why. I guess updates or stuff.
Chief Schinkel has ordered a new computer that should be in soon.
Good. Well, they just apparently logged out.
If they have to restart the computer.
Right, yeah. But I don't know how that happens. And on microphones. This morning I had a problem too.
Back on record.
All right. This is case number 22 CR 13, State of Ohio versus Bradley B. Hickson. Are you Bradley B. Hickson appearing there from the jail?
Yes, I am, sir.
All right. Mr. Hickson is appearing on a probation violation evidentiary hearing. His attorney is Catherine Hapner. This hearing is being conducted by Zoom. Mr. Hickson is appearing from the jail. Ms. Hapner is appearing from her office. Appearing from the prosecutor's office is Prosecutor Collins. Ms. Hapner, are you and your client both in agreement this matter can be conducted by Zoom rather than in person?
Yes, we are.
And you're all right with that, Mr. Hickson?
Yes, Your Honor.
All right. If at any time during this hearing you need to ask her any questions or talk with her about anything, just tell me. I can put you and her in what's called a breakout room. It'll be just the two of you on the screen talking. No one else that's here on the screen can see or hear you. And the deputy will step out of the room during that conversation, so it's confidential, okay?
Right.
All right. Now, Mr. Hickson was placed on community control back on January the 4th of 2023 for aggravated trafficking in a fentanyl-related compound, a 4-3 felony. There was a notification filed on November 27th by Officer Arjima, who's also appearing here from the probation office, that alleges that he violated. There was also an additional entry filed on November 9, 2023. The allegation is that Mr. Hickson violated Rule 2, that honor after May 22nd of 2024 he failed to report, and then on Rule 19 that honor after July 18, 2024 he failed to complete aftercare at Samaritan Behavioral Health after completing the STAR program. Now that was filed by Officer Arjima on the 27th of November. Mr. Hickson was informed of that on November 27th or 8th, I can't remember now, and Ms. Hapner was appointed to represent him, and the matter was set for hearing. Now, Ms. Hapner, have you had the opportunity to review the allegations with your client?
Yes, I have.
All right, does he wish to have a hearing, or will there be an admission?
No, Your Honor, he will admit, but he does have an explanation to give.
Okay. So, Mr. Hickson, you do have a right to have a hearing on this matter in which the prosecutor would have to present testimony through witnesses or other evidence that you have failed to comply with the conditions alleged. You have a right to have your attorney cross-examine the witnesses for the state to try to help your case. You can offer testimony on your own behalf for any other witnesses you may have as well. In the event that it's found you have failed to comply, whether that be through a hearing with witnesses or through your own admission, I can do one of three things. I can continue your community control under the same conditions previously ordered. You continue it with additional conditions that I think are appropriate, including extending it to up to 5 years. And the third and the most serious is I could revoke your community control and then sentence you to prison for between 6 and 18 months and fine you $5,000. You understand that?
Yes, Your Honor.
All right. And has anyone promised you anything or threatened you in any way to get you to make this submission?
Yeah, Your Honor.
All right. Then is it your decision to admit the allegations that were filed against you that I just read to you and informed you about on the 27th of November?
Yes.
All right. All right. Anything from the state regarding disposition?
Your Honor, on behalf of the probation department, we would ask that the defendant's community control be revoked. This is the second violation. He has previously been violated in order to enter and successfully complete the STAR program. Reporting to probation has been the primary problem here. He has reported only 3 times since completing the STAR program, which was a year ago. And prior to that, reporting had been a problem for him. So based on that, we would ask the court to revoke the defendant's community control and sentence him to a term of incarceration.
All right, Ms. Hapner?
Thank you, Your Honor. Your Honor, I did speak with my client last week. He has indicated to me that he's on probation in Greene County also, and that he had requested that his probation be transferred to Greene County, so he'd only be reporting in one place. He also indicated to me that he spoke with his probation officer in Greene County and was informed that they would accept that transfer because he was already reporting there and on probation there. And so he reported to me that he believed that his probation had been transferred and he only had to report there as opposed to Greene County and Highland County. I don't know whether that paperwork was completed or not, but that was his understanding. And so he indicated he was not trying to ignore down here, but he thought he only had to report in the one place. He did complete the STAR program. He did not complete the Samaritan Behavioral Health for the aftercare, but my understanding from him is that they had lined up a different aftercare for him through Greene County.
Okay, Mr. Arjima, are you aware of he's being under supervision in Greene County?
So I looked it up. He was successfully terminated in April of this year, which would have been prior to his last time he reported to me. So he did mention he wanted to transfer, and I told him he would have to report to me so we can get that paperwork started. And he could never get himself to Highland County.
Okay. Mr. Hickson, you have anything you'd like to say?
Yes, Your Honor. So when I completed CCC, that was when I was on probation for Greene County and Highland County in January 4th of 23. At that point in time, I went to Full Circle for a little while. I didn't care for the program there. I transferred I completed at, I went into an inpatient rehab, Woodhaven in Dayton, completed there.
When was that?
Would have been February 2nd of 23 to April 22nd, I believe. It was like 45 days of 23.
Well, that's all before the time we're involved here. This is all,
I know, I'm just
we had
trying
a hearing in November and you were told to complete STAR. So what's at issue here is from November 9th of 23, after you got out of STAR, what you did.
Okay, all right. Well, I was just trying to fill in the gaps of where the Greene County was going.
Well, there's no gaps. We're just
That's fine.
interested in a point of continuum from November 9 to 23.
Okay, so when I completed STAR, Greene County terminated my probation when I completed. From then, when I completed STAR, I went to the probation department in Highland County and asked them to transfer my probation at that point in time. Mr. Arjima said they would try to, and the next time I reported in was basically the same. It was whatever, a week or two, I don't know, 2 or 3 weeks later. Same result. I was told that they would try to. The third time, my last time of seeing them was the same. My ride is almost 60 years old. I don't have any way of getting back to Highland County. I work in Montgomery County. I live in Montgomery County. I don't have a car of my own. I work. I paid off my fines. I'm doing what I need to be doing. I'm not using. I'm happy to continue probation and doing the aftercare. I was told at STAR that it was an option for me. It was a recommendation. It was not mandatory for me to complete an aftercare. That was told to me from Mr. Hess.
Yeah, but you know who told you you had to? Me. In case you don't understand this, judge trumps STAR. Judge is a court order, STAR is not.
Okay.
Okay, that's number one. Number two, I don't believe that. They don't do that. They know better. It's in the entry. So I don't believe you. So, you know, if you have anything else to say, let's make sure it's truthful.
Your Honor, that is what I was told. I mean, I don't know how else I can prove it. It's Mr. Hess that told me. If I can talk to him, I will.
All right. Anything else, Ms. Hapner?
Your Honor, he did pay off his court costs, so, you know, he's doing something he's supposed to be doing. He was working. He's indicated to me that his employment would still be available to him upon his release from custody.
All right. Well, as I said, Mr. Hickson, I don't believe that story. Number one, you were told that, and you just basically admitted on your own that you just quit going. You wanted them to try to transfer. You had trouble getting a ride. Well, you know, that's something that you should have been in communication with them about. You just don't quit reporting, you know. There's been so many stories here told here. Obviously, you told your lawyer something different and then what you just told me. Because you couldn't have even, you weren't still reporting in Greene County. That stopped even before you were here, and I put you continued community control. And your history shows you just don't report, and you're not doing anything you want, what you're supposed to do. And you know, we don't know if you're clean or not because we weren't able to test you. since you weren't reporting. And based upon your, what you've just said, I mean, it's clear to the court that you're, you think you're in control and you're not. And I don't believe for a second that anybody at Star told you it was optional. It may have been optional at that location, but the order said you will do aftercare. If you don't go to one place, then you get another place, but you go somewhere. Also, you discuss that with your probation officer, because your probation officer is the court supervisor. Star is a provider. They don't get to make any decisions, and they don't. And I know those people down there, they come up there. We have somebody from drug court here every 2 weeks. Now, I know better than that, and I know that that's not true. So it's ordered the court that your community control be revoked. And Mr. Arizimi, you know how many days he had from Star?
140 days, Your Honor.
All right. All right. So it's the order of the court that you be sentenced to a term of 15 months. You get jail time credit, according to the sheriff, of as of today, 56 days, 142 days from Star. That'll be a total of 198 days. Upon completion of your sentence, it is possible the Adult Parole Authority will put you under post-release control. They don't have to, but they can if they do. You'll be supervised on the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that will be served consecutively to the sentence of the new case. You're also ordered to pay the court cost. If you fail to do that, those can be collected by the clerk by various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, the court could permit you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody.